Welcome back to our next segment on disability and employment with our Perspectives on Disability MOOC. In this segment, we're going to talk about legislation, specifically the Americans with Disabilities Act. I have found certainly that in teaching and in talking to other colleagues, as well as administrators and so forth, there's a vast lack of knowledge with regard to the ADA and what its impact is on employment. And so from my standpoint, even just a little bit of introduction to this is hopefully going to be helpful, and again, would encourage you to look at our resources to find more information on this. As a starting point, I would say that the Americans with Disabilities Act applies to lots of companies, but that company has to have at least 15 employees. Not full-time, but just if you have 15 employees or more, the ADA is something that you have to abide by. The employment title associated with this law is one of the more controversial aspects of the ADA. Unfortunately, many employers have little knowledge or awareness regarding it. As such, employment myths abound. The U.S. Department of Labor has a particularly interesting document about this topic. A link is provided in your weekly readings. Some of the more prevalent myths include the belief that the ADA forces employers to hire unqualified individuals with disabilities. This is incorrect. Potential employees must be qualified. They must be able to meet the essential functions of the job with or without an accommodation. A second common myth is the belief that when there are several qualified applicants for a job and one of them has a disability, that the employer is required to hire the one with a disability. Again, this is not true. The employer always has the option to choose among qualified candidates. He or she cannot, however, base the decision on the applicant's disability. And a third myth is that the ADA places a financial burden on small businesses that cannot afford to make accommodations. Again, this is not correct. Businesses with fewer than 15 employees are not required to abide by the ADA, and in addition, businesses are not required to provide accommodations that result in undue hardship. In the previous slide, there were three concepts that I'd like to briefly explain. Specifically, I want to mention the ideas of essential function, reasonable accommodations, and undue hardship. Essential functions pertains to the nature of the job. That is, what are the specific skills, knowledge, and abilities required to perform the task? For example, imagine a taxi company is hiring drivers. Now, certainly an essential function associated with driving a taxi is the ability to see. Suppose someone who is blind applies to be a taxi driver. When they were not hired, could they subsequently file a lawsuit claiming discrimination? Based on the idea of essential functions, they could not. There is no accommodation available that would allow someone who is blind to safely drive a cab. Alternatively, though, if that same company were hiring dispatchers, receptionists, or business manager, there would be a different interpretation. Because with appropriate accommodations, someone who is blind could most certainly meet the essential functions associated with those jobs. We also mentioned the idea of reasonable accommodations. By definition, a reasonable accommodation is any change in the work environment or in the way a job is performed that enables a person with a disability to enjoy equal employment opportunities. And that these changes tend to fall in three categories: changes to the application process, changes to the work environment or the way a job is usually done, and changes that enable an employee with a disability to participate in training so as to have equal benefits and privileges. The one thing, though, and this is a very, very critical point, because I think a lot of people don't know this or misunderstand this. To be protected by the ADA, okay, the individual must be able to perform the task with accommodation. The idea being that you as an employer are not ever obligated to hire an unqualified worker. Would also mention, when we talk about this idea of getting accommodations, that the individual has to disclose. If you have a disability and anticipate the need for a job-related accommodation, when do you describe your disability? Again, as with most of our topics, there are additional resources available for you.
Would I disclose? Yes, I think I would disclose, because my disability is visible. And so I kind of want to let people know that to begin with, and that way they're not shocked when they see me. That way I can kind of limit the really good chances of getting a job from the people that, might not want to hire me just because I have a disability. it kind of saves me some time, and it makes me feel a lot less nervous when when I am interviewing, because even though I am seen in this wheelchair or with crutches, a lot of times people don't know what my disability is. So I think it is good for me to disclose, but I could understand if someone had a hidden disability that they wouldn't want to disclose.
I usually disclose my disability beforehand, before the interview, because of the need for the interpreter. Sometimes, sometimes I don't disclose until the moment, because I bring the interpreter myself. It all depends on how I feel, the attitude. Oh, usually. Employers, often they look at my ear, they don't look at me. They just look at my my broken ear, if you would. That's why that exposure is necessary. Someone else, on the other hand, who may have a mental illness or learning disability, whatever it might be, not necessarily, right? You're not going to know that. So the issue of disclosure is a really big one, because as an employer, think about this again. Would you be more willing, just gut level here, not talking laws, but if somebody came in and had a invisible disability, and you had another applicant who had no disability, and this person who had that invisible disability, let's say it's a mental illness, and they disclosed at the outset of that interview, which of those two people would you be more likely to hire? So in summary, the ADA does provide employment access, but it doesn't mean that everybody's going to be hired simply because they have a disability. You have to meet the essential functions, and accommodations have to be reasonable and not pose an undue hardship. We've got that notion of thinking about the importance of disclosure. Do you or do you not? Because unless you disclose, you are in no way entitled to a disability. And then finally, those myths about the ADA that it's going to be incredibly expensive, or that you've got to accommodate everyone. Again, that's not accurate. So we'll close this section, and as we move on to our next segment, we'll be talking about support strategies and solutions.